I'm Ronald Thwaites. I've been practicing law in Jamaica for over 50 years. And I'm happy to have these conversations with you about legal matters that concern everybody's lives, whether you live in Jamaica or you live abroad. Now, please remember, this is not a substitute for consulting your own lawyer if you have a particular issue or problem. Listen up.
Does it matter legally if we marry or just live?
No, it's very different. The legal obligations of marriage are very precise, and there are some legal obligations between parties who live together, but let's separate them. First of all, marriage is a legal contract. It's a permanent contract until otherwise dissolved, and it implies and involves obligations between the parties. Obligations of faithfulness, obligations of support, obligations of maintenance of children, if there are, and even if there are not, of the union, there are concomitant responsibilities. Because of the prevalence of people living together, the law has provided that if you are living in exclusive relationship with someone for 5 years or more, then many of the obligations and the rights of married parties are available to you. But the two states in life are very different.
Who can get married according to Jamaican law?
Any person who is not a lunatic, and any person who is over the age of 18 years or below 18 years, over 16, with the consent of their parent. And let me be clear, two persons of different genders.
Does marriage mean that all of one party's property becomes the property of the spouse?
No, it does not mean that. It means that there are certain presumptions that the properties that are acquired during the course of the marriage are jointly held, meaning there's equal undivided shares. Yes? But that can be rebutted if by actual evidence. If, for example, a husband buys a house other than the matrimonial house, home, and he pays for it entirely, or vice versa, a wife does, then it cannot be assumed that the other party will have a share in that separate property. It's different in the matrimonial home because the presumption of jointure is much higher when two people live together, even if a husband or wife are offering just domestic services, just being a housewife or a house husband. The presumption is that what you do in or around and to your matrimonial home is intended to be for both of you.
What about children from a previous relationship? How does marriage affect that?
If you marry a person who has previous children, and they're under 18, you assume the responsibility for caring them. And that's very important. That responsibility can be mitigated, can be softened if in fact a parent of the child of the previous union is in fact contributing. But what the law wants to ensure is that by virtue of the marriage of one parent, they are not denied the full support of two parents, at least financially.
What is meant by matrimonial home and matrimonial property?
Matrimonial home is where you live with your husband or your wife. That's the simple definition. It can be more than one place, but it usually is one. And it assumes, again, a joint contribution to its, maybe not its acquisition, but certainly its welfare. And the principle behind the law is when a person is joined, two persons are joined in marriage, that they have maybe unequal, but nonetheless shared responsibility for creating a home. Now, matrimonial property can be more than the home, you asked. If there's a nice issue of shares, for example, and husband says or wife says, can we pull together our savings and buy shares into this company? And we do them in one name for whatever reason. But the other person contributed. That's part of matrimonial property. May not be 50-50, yes, but unless it's proved otherwise, it will be treated as 50-50.
What if it does not work out? How long does one have to wait before divorce?
At least a year. And usually there is a requirement, nominally at any rate, that you make some efforts to see if the differences can be reconciled. And that's quite a contracted period from what it used to be. And there is a single ground for divorce in modern times, and that is the irretrievable breakdown of the marriage. It used to be that you had to prove desertion of one party or the other, you had to prove adultery, which was particularly juicy and uncomfortable, or you had to prove cruelty. And that all of those things were unseemly and have been removed from modern law. And basically, the law prescribes, that persons must not take the marriage bond capriciously, but that if they have tried for a period longer than a year, and if they have made the effort when problems arise to gain some counseling, some effort, and it is clear that there's an irretrievable breakdown, that's the phrase, then they may proceed for divorce.
What is an annulment? How is it different from a divorce?
A divorce is a declaration that a marriage has come to an end. An annulment is a declaration that a marriage legally never existed. There are circumstances perhaps which require explanation. If in fact a person was not honest about their age at the time of a marriage could not legally take place. If a person could prove that they entered into a marriage which was shotgun, they were under duress, then they didn't give their full consent, then the marriage never existed. If the proper form of marriage was not followed, then obviously the marriage was not properly solemnized. Whatever went on, however grand the reception might have been. If there are many other instances, if, as terribly sometimes happens, people get married but forget or pretend that they weren't married before, then the subsequent marriage would not be subject to a divorce, but would rather be the subject of an annulment.
What are the grounds for divorce, the procedure, and the likely cost?
Well, I've told you what the ground is: irretrievable breakdown of the union. The procedure is a petition to the Supreme Court of whichever jurisdiction by one or another party, called the petitioner. The other party, who is called the respondent, and the proceedings have to be served on the petition pleading for divorce, has to be served on the respondent. Okay, it can't go through if that doesn't happen. This is important because if there are children involved, or if there's property to be divided, then both parties have to have a say in how that goes. So it's a petition. It has to be served upon the respondent. It has to state clearly when the marriage took place, what steps have been taken to resolve the difficulties. It has to give a declaration that the marriage, in the mind of the petitioner, has broken down irretrievably. And it has to spell out the arrangements being made for any consequential persons or business. Yes? When that is properly done, and the respondent has been given a chance to reply within a period of time, very often has not done so, or even if he does, then you go through two processes. One is called a decree nisi, that means a decree unless, and then a short period after, you may apply, if there's nobody intervening, there's no consequential matters that have to be dealt with, you get what is called a decree absolute. Important to know that when you get the decree nisi, you can't marry again right then. You have to wait until the decree absolute is given. Yes, that is the absolute ending of the marriage. It can run from 150,000 Jamaican dollars, it's roughly $1,000 US, to multiples of that, depending on the complexity.
How does the split up of property and the obligation of maintenance go in a divorce?
Basically, according to ability and to need. Let me explain. Need is very important. A party to a marriage who is a father or a mother to a child is bound to maintain them. And the level of maintenance will be related to need of the child. Need of a preschool child is very different from a university child, or a child who is healthy versus one who is ill. So that's one thing, need. And the other thing is ability. The court will not grant millions of dollars of maintenance to a person of very limited means. But the court will always place great responsibility on the parent, say, or a spouse whose other spouse is in great difficulty, perhaps has a very expensive illness, maybe having a challenge that prevents them from earning. That will depend on the level of maintenance that's offered, that's required. And you got to pay that, eh? And if you don't pay that, the person who is entitled to it, the parent who has guardianship of the child, or the parent or the spouse who is affected by the divorce adversely, can take the other party to court. And if they do not pay, they go to jail.
Is a foreign divorce recognized in Jamaica?
Generally, yes. Now more than ever, there is a fair pattern of rules relating to marriage and the dissolution of marriage. And therefore, I can give that general answer. But there may be circumstances where the marriage was so informal that it needs to be validated by a local process. And please, we hear in the history of some countries that if a party says, I divorce you, I divorce you, I divorce you, that's the end of it. That won't be recognized here.
What are the obligations to a common law spouse?
If the parties have been living together in exclusive partnership, not in a visiting relationship, not in indelicate phrase, one-night stands, in faithful concubinage for 5 years or more, then there are presumed to arise obligations between the parties. They do not rise to the level of a married spouse, but the same principles about sharing matrimonial property or sharing, let me not use that, that's confusing, sharing common property will apply, and certainly the same rules in respect of the maintenance of children.